Aren't we, the people, whether we're the legal profession or the public, entitled to free access to our law?
We believed that the public had a right to access primary legal materials because they're expected to understand what the law is if they're going to abide by it.
It's respecting the public, the general public, enough to know that if you give them the material, that a substantial number of them will use it and will understand it.
There's always been some information available, and the idea of it being for free is a bit disturbing to parts of the legal profession.
They all thought we were nuts for one reason or another. It was sort of, well, why would you do that at all? Why would you do that when we enjoy such good access to these materials through the commercial information services?
What we're trying to do is to use our interest or our expertise or knowledge about the technology to make the legal system better.
And so it was partly born out of a desire to be able to teach properly and to do research properly, and frustration that the materials simply weren't available to anyone.
The profession started to say, and particularly the Federation of Law Societies, which is the umbrella organisation, we should be self-publishing, because they felt it was unfair that they create the law by going to court on behalf of the clients. The judges write the decisions, the publishers, commercial publishers, take them, they sell them back at a premium to the legal profession, and then when they want to use them, charge them with infringing copyright.
We had very high corruption levels in Kenya. The lawyers were operating by rumor. I mean, they would appear before a judge and say, there are numerous decisions on this point, and the judge is staring, and all of them are wondering where to get the numerous decisions. So you can imagine, I mean, as long as a judge knows that their judgment is going to go to the archives and hopefully disappear, and hopefully there'll be a fire someday, you can imagine what they can have in that judgment. And I used to have students writing in their exam papers, in the unreported case of Kamau versus Kamau, and then they make up the facts and make up the principle of law. And you have to mark it correct because you had no way of verifying.
In 1996, I started in the Solomon Islands as a legal volunteer. I was out in a remote western province. The only laws we had was a bound copy that was up to date till 1969. Everything else was in loose leaf. There was no way of telling, if anybody asked you what the law was about anything, exactly what the law was.
I became fascinated with digital technology and its effect on law, or its potential effect on law, in the late 1980s.
Andrew Mowbray and I had been working since about 1984 in the area of legal expert systems as one of our areas of research.
In the 80s I was involved, I was very much interested by artificial intelligence in law, which was really trendy at the time. Many people were thinking about doing expert system, but I was not that good at it.
I had been working doing IT support for legal education and had gotten interested in the internet as a method of distribution for all kinds of texts.
I discovered that the commercial entities that were involved in law publishing at the time were utterly baffled by what was happening around them, that they didn't understand what the implications were of digital technology for their business. And that led to conversations with my technology friend, Tom Bruce, and we decided that we would create an activity. What would we call it?
Peter Martin, who was my co-founder, and I were somewhat stuck for a name to call this thing that we were doing. And Legal Information Institute seemed to be sufficiently generic to encompass all sorts of things that one might do.
Our first notion of what we would do to disseminate basic legal materials was, again, to put them on disk.
We'd decided that we needed to integrate expert system technology with free text retrieval and with hypertext. So in the sort of pre-World Wide Web period, Andrew had written some very good tools, search engine and hypertext engine.
And it seemed to us, along about 1991, let's say, that a couple of things were needed. I mean, one was to bring the legal publishing activity together with the legal education activity on the sort of substantive side, and the other was to bring hypertext technology together with internet distribution on the other.
And my partner Tom felt the need to create a web browser, because at that point the only web browsers ran on Unix machines, and so there was nothing for the hardware that most law people had in their offices on their desks. So that Tom created the first Windows browser for the web. Then we were the first non-institutional and non-scientific website.
By about 1994-95, because of the Mosaic browser, and we could see there was an opportunity to shift all of the things that we'd previously developed into something that could create free access to Australian legal information when there wasn't any such thing available.
We looked around at the available search engines of the time. None of them were really suitable for what we wanted to do. We were very conscious that we were going to build something very big, so we needed to have something that would scale well. So I sat down over a very short period, about 2 weeks. I managed to stay away from work as much as I could, and I wrote Size is No Object. It was not meant to be a boast that we could handle anything you could throw at it. What it was really doing was it was saying that we're going to not care about the size of the indexes that we're generating, or we're not going to care about disk space. We're going to do whatever it takes to get speed.
In 1993, as far as I can think of, I think there was only 4 websites in all Canada. It was really the beginning of it. So publishing the law on the internet was a very bizarre proposition.
We also discovered early on that the Supreme Court was depositing its decisions in digital format at an FTP site. What we did without holding the content itself was to create a set of hypertext links to the documents that were at the Case Western site, which allowed people to see what was there as a case name and then to click on it if they wanted it.
It was not easy to get data. And even if you were able to get the data, it was not in the format that you would like. Say, for example, the Supreme Court would give you decisions in parts, so you never know until when the whole decision is actually there, and you get it in floppy disks.
Like one of the big things we had to solve along the way was how to tackle the various issues around the privacy, because the justice is public, but quite often judgments contain information which is very private.
We found ourselves on the front page of the Sunday papers. And in fact, we made, I think, 4 of the 5 nightly news on a Sunday night. And the story basically was 2 Sydney academics disclose family law court secrets. And we did take the data down, and we did get out of our houses because we were a little worried we might have the bailiffs arrive.
So we had to integrate in our publishing model a lot of safeguard.
There were very few websites at that point, right? So as this stuff started becoming visible, we all began finding each other. I remember getting an email from Graham and Andrew saying, hey, you mind if we use the name? And the answer was, no, of course not. I mean, it's a generic label, feel free.